Thank you. Welcome you to our committee. I know our host is going to be 3 speakers today, and you only see 2 in front of you. Unfortunately, speakers that are responding is sick and unable to join us today. We are happy to have Ilya Shapiro and Christina Laser. Sorry, Laser. So our first speaker is Ilya Shapiro. Shapiro is a senior fellow and director of the Constitutional Studies at the Manhattan Institute. He previously was an executive director and senior lecturer at the Georgetown Center for the Constitution. Before that, was vice president of the Cato Institute and director of Cato Roberts A. Levy Center for Constitutional Studies. Mr. Shapiro is the author of Lawless, the Miseducation of America's Elites and Supreme Disorder. Nomination and Politics of America's Highest Court. He's a co-author of Religious Liberties for Corporations and the editor for 11 volumes of the Cato Supreme Court Review. We also have with us a professor of our own, Professor Laser. Professor Laser has nearly a decade of practice experience as an intellectual property litigator at the law firms of Hill and Kirkland and Ellis, LLP. She has a deep expertise in patent, trademark, copyrights, false advertising, pharmaceutical litigation, regulation, and technology law. She has represented leading life sciences and technology companies in all stages of trial and appellate matters, and consulted on legislative changes to intellectual property laws. The format for our structure today is we're going to let each speaker start with a quick open. Following that, we'll be asking a few questions, and following that, we'll go with questions up to you. So to jump right in, we're going to start with Mr. Shapiro, his opening statement.
Great. Well, thanks for having me. I've been here in the past, and I'm glad that I didn't do anything to disinvite me now. I was just listening to Charles recite Professor Laser's background, and it made me think, we were just joking beforehand, that between the two of us, we have enough knowledge to understand the whole case, kind of like the blind man and the elephant looking at 2 different sides. It's too bad that Professor Moncrief couldn't be here for the synthesis. How many of y'all use TikTok? Maybe 40% or something like that. I don't, but I hope that you all get to. I hope that the Chinese do divest and all that. It turns out, people complain about the social media effects on teenagers' brains of TikTok and all this stuff. And it turns out that this platform owned by the Chinese company ByteDance goes viral significantly more among younger folks than Instagram, Facebook, Twitter, X, what have you. And the problem, though, and the reason why we're having this event isn't because of a debate about whether it's bad for you or should be, regulated or content produced or rule, for restricted to minors or something like that. That's a different kind of policy debate. The problem is that it allows our enemies to engage in psychological warfare, collect data, do things that we might not like. To give one example, TikTok drove an epidemic of apologias for Osama bin Laden last year. Some allegations that this was manipulated by whoever, not our friends. Now, to its rare credit, Congress decided to do something about this problem, and in a bipartisan manner. It passed the Protecting Americans from Foreign Adversary Controlled Applications Act. I don't know if anyone calls it PFACA, which is kind of the unwieldy acronym, but Protecting Americans Act is how most people talk about it. And this would force social media companies owned by America's foes, notably China, Russia, North Korea, and Iran, to find new ownership or lose App Store availability within 180 days. As it happened when it was enacted, that 180 days ended January 19th, the day before Inauguration Day. Despite heavy lobbying by big tech, these platforms that gloried themselves in censorship to foil so-called misinformation, speech the government doesn't like, have become born-again libertarians. And have joined with my former colleagues at the Cato Institute to argue that this is a ban and it would stifle speech. Now, I take a backseat to nobody in advocacy for the First Amendment, for freedom of speech, but this isn't that. This is investiture legislation that regulates foreign control of American information platforms, which is not a new thing. As I told Jeff Yass, who's a billionaire investor in TikTok, he's kind of become the face of opposition to the bill. And there are hints that maybe his meetings and maybe financial support for Trump's campaign caused Trump to change his mind on all this stuff. But anyway, I would like nothing more than for Jeff Yass or someone else like that to own the app rather than the Chinese. And regulating the ownership of communication channels is nothing new. From the Radio Act of 1912, which forbade foreign ownership of radio stations, to the FCC's denial 2 years ago of China Mobile and China Telecom, their ability to operate cell phone service in the US, foreign control of information has been a subject of significant federal interest. There are FCC rules dating more than half a century, restricting foreign ownership of media broadcasters. You can imagine Mike Gallagher, who's a friend of mine, one of the former congressmen, is the chief architect of this law. He had a piece in the Wall Street Journal saying, imagine during the height of the Cold War, the Soviet Politburo tries to buy ABC, CBS, NBC. That sort of thing could have been blocked without First Amendment concern. Now, many critics admit the bill does not really restrict the content of speech, but nevertheless argue that it violates the First Amendment because either TikTok isn't really a national security threat, so the bill is kind of disproportionate or what have you, or that some lesser means, there's some alternative means would have addressed the threat. But here's what we know, at least from public sources, and the court was eventually made its ruling. There are some confidential classified materials, but the decision that the Supreme Court ultimately made didn't rely on that. I think that's appropriate. TikTok allows the Chinese Communist Party to, quote, control data collection on millions of users and technically compromise their devices if it wants. And that's because ByteDance must comply with the CCP's demands, and TikTok is controlled by ByteDance. So it's no surprise that we've already seen TikTok let ByteDance access Americans' private information and track US journalists. We also know that ByteDance let the Chinese Communist Party inspect TikTok's internal platform in the lead up to the last party Congress. Nor is it true that China can replicate TikTok's capacity through other means for espionage or whatever else it might want to do. Having a social media company under the thumb of a hostile powers intelligence service with the capacity to access 170 million Americans' devices, running in the background, who knows what it's hoovering up, is much more effective than, say, licensing data from a broker or otherwise fishing for information in the digital ocean. But doesn't focus on TikTok make this a bill of attainder, right? You're not allowed to search out and punish a particular person or entity that you don't like for activities that aren't otherwise illegal. Well, no, because there's no punishment here. It's not fining TikTok for doing something bad. It's a forward-looking demand for divestiture, regulating conduct in a forward-looking manner based on national security, as the Congress has done in other cases with court approval. And so even though, for example, Montana's attempt to ban TikTok failed because it's a state and can't speak to national security, and even though Donald Trump's executive order attempting to ban TikTok failed because it's not something that the president can do on his own, this is a different sort of case. And finally, another organization whose free speech bona fides can't be questioned, with whom I partner all the time. I just recorded the podcast for the Foundation for Individual Rights and Expression yesterday. They argue that all options for divestiture must be exhausted before the government takes the unprecedented step of banning the platform. And I fully agree with that. The Committee on Foreign Investment in the US, CFIUS, which is involved with port takeovers, and they made a recommendation to President Biden not to block the Nippon Steel's takeover of US Steel, which he rejected. I disagree with that decision, but anyway, CFIUS is heavily involved. They ordered TikTok already to separate from ByteDance back in 2020, but TikTok has done everything in its power to avoid that. And the alternatives simply have all been exhausted, as Justice Gorsuch would end up writing in his concurrence in the Supreme Court case. Actually, 5 years ago, CFIUS forced a Chinese company to sell the gay dating app Grindr under the same rationale. And so critics' arguments get this exactly backwards. If you care about free speech, you should care about whether social media platforms are controlled by a communist dictatorship that want to sow chaos and destroy the freedom and privacy that we take for granted. The only way to ensure that Americans, especially young Americans, continue to enjoy their rights is to ensure that our political culture isn't corroded by foreign influence through the everyday tools we use to communicate with one another. And the Supreme Court essentially agreed with that, having briefing, an argument, and a decision on an expedited basis, and finding that even if, even assuming that the First Amendment is implicated, this regulation is subject to intermediate scrutiny because it's content neutral. Whether it is or isn't, I think I agree with Gorsuch that it would even survive strict scrutiny because, again, it's a national security concern, a compelling government interest, narrowly tailored. But in any event, the court was unanimous. We saw that in argument, skepticism of the challenger's position by everyone from Clarence Thomas to John Roberts to Ketanji Brown Jackson. I agree with that. I think it's telling that the Chinese have decided not to take their $125 billion profit or what have you, tried to pay lobbyists to try to block this. We'll see what ends up happening, whether President Trump can negotiate his big, beautiful art of the deal, and I don't know, have Elon buy it with the consortium. Who knows what's going to happen? I don't think it's lawful, by the way, for the president to issue an executive action just to block enforcement for 75 days, but that's another matter. But that's where we stand.
And if you wouldn't mind, I might love to play that clip if possible for folks before I start my discussion. So my main perspective on this is that the ban actually is about regulating the content of the communications that take place on TikTok, and that the national security concerns stem both from a lack of understanding of the technology and from trying to find some sort of explanation that isn't content-based to try to justify the ban. So I've sent over a little clip, just 3 minutes long, of the hearings. And in this clip, we see some of the questions that the senators asked the CEO of TikTok reflect quite a lot of misunderstanding of how technology works and reflect primary concerns over the content appearing on the platform, rather than the likelihood of the Chinese Communist Party accessing data on specific individuals. Sorry for surprising you with that.
I'm happy to stipulate the senators don't know anything about technology.
You emailed that. Correct?
Yeah. Send it again, or do you have it?
Yeah.
All right, 1 second.
This is why I never use AV aids in my presentations. At least this isn't PowerPoint. I have a joke that PowerPoint is unconstitutional, at least as applied 90% of the time.
Yeah. Sorry about this. Okay. No worries. All right, so while we're waiting for that to get pulled up, I think right here, it's important to know what the Supreme Court did in response to this request for a ban. So very briefly, the Supreme Court opinion ended up finding that there was no First Amendment violation from the passage of this act, and they applied intermediate scrutiny. When they did that, they basically determined that this was a content neutral law. And we can turn off the, we can skip the ad or mute it while we wait for the ad.
Yeah, sure.
Sorry, that's great. And so it's a content neutral law, which is subject to intermediate scrutiny instead of strict scrutiny. And so this intermediate scrutiny, they're going to be looking at whether the law advances important governmental interests unrelated to the suppression of free speech and does not burden substantially more speech than necessary to further those interests. So the two things that we're trying to figure out are, is the thing that's trying to be blocked about blocking speech? Does it further some important interests like national security instead of just trying to burden speech? And then second, are there less restrictive means available for preventing the type of conduct that they're concerned about? So here, in the context of the national security concern, when you look at some of this hearing information, you'll see that they are primarily worried about things like the Chinese government pushing certain content towards US users that could be harmful to US users. And that certainly does happen, but it happens on nearly every platform. We see that anybody has the power to push content on social media platforms by controlling the types of ways to try to incentivize virality of content. And that's something anyone can do. We saw the Russians do this on Instagram, for example, to try to sow disconnection between men and women in the United States, for example. The Russian government was trying to promote virality of content directed towards men that would have anti-women viewpoints, and virality of content directed towards women that would have anti-male viewpoints. And as you might guess, that could undermine some of the stability in society if you have large groups of people angry at each other and having very different viewpoints. And we see that China does this a lot as well, and they do it on TikTok as well as on other platforms. But the concept of, you know, being able to make something viral is not something that content platforms should really be banned for, just because some entity is able to promote more viral content that could be harmful. I think that trying to educate the population to make choices about the types of content that they watch and how the algorithms could impact what they see is a better way of doing that than saying you just can't watch that kind of content. We're going to ban the app entirely. And the Supreme Court said, well, look, it wasn't really a ban. This was a divestiture requirement. But when you require a company of that size to divest in 270 days, it's effectively a ban. So let's look at the clip so we can see, do the legislators that are looking at this actually understand what they are legislating on? This is the testimony of TikTok CEO. He is based in Singapore.
Can you say with 100% certainty that TikTok does not use the phone's camera to determine whether the content that elicits a pupil dilation should be amplified by the algorithm? Can you tell me that?
We do not collect body, face, or voice data to identify our users. We do not. The only
You don't?
the only face data that you get that we collect is when you use the filters to have, say, sunglasses on your face. We need to know where your eyes are.
Why do you need to know what the eyes are if you're not seeing if they're dilated?
And that data is stored on your local device and deleted after use if you use it for facial. But again, we do not collect body, face, or voice data to identify our users.
I find that hard to believe. It's our understanding that they're looking at the eyes. How do you determine what age they are then?
We rely on age gating as our key age assurance.
Age
Gating, which is when you ask the user what age they are. We have also developed some tools where we look at their public profile to go through the videos that they post to see whether
Oh, that's creepy. Tell me more about that.
it's public. So if you post a video you choose that video to go public, that's how you get people to see your video. We look at those to see if it matches up the age that you talked about.
The 10-year-old girl participated in a blackout challenge, also known as the choking challenge. TikTok actively pushes video on her feed. Unfortunately, this is one of the many devastating examples of children losing their lives because of content promoted by TikTok.
Congressman, as a father myself, when I hear about the tragic deaths of
My
young
question is,
people,
do
it's
you
heartbreaking.
find that good faith moderation?
We are very focused on safety, and all
Okay,
these
I'm
dangerous
gonna have to
challenges
assume
are
that as a
removed when
no.
we find them. There are more than 150 million Americans who love our platform, and we know we have a responsibility to protect them, which is why I'm making the following commitments to you and to all our users. Number one, we will keep safety, particularly for teenagers, as a top priority for us. Number two, we will firewall protected US data from unwanted foreign access. Number three, TikTok will remain a place for free expression and will not be manipulated by any government. Data is stored here in American soil.
Your TikTok employees that live in China, they must cooperate with Chinese intelligence whenever they are called upon. And if they are called upon, they're bound to secrecy. That would include you. So, Mr. Chu, if the CCP tells ByteDance to turn over all data that TikTok has collected inside the US, even within Project Texas, do they have to do so according to Chinese law?
Congressman, first, I'm Singaporean.
That's fine, but there are employees of yours and ByteDance is in China.
We understand this concern. In my opening statement, we said, we hear these concerns, we didn't try to avoid them or trivialize them. We built something where we take that data and put it out of reach.
The Chinese Communist Party is engaged in psychological warfare through TikTok to deliberately influence US children.
So if you look at some of the clips, you'll see there's two things that were emphasized here that I want to repeat. One of them is that the CEO made clear that there are some options to try to limit the ability of the Communist Party to access that data. One of which is to put up a firewall around the data of US users. Currently, that data is stored by Oracle, which is based in the United States. And they tried to set up ways that make it so that it would be physically impossible for the Chinese government to access that data. So that in my personal view, that would be a less restrictive means to try to say that if you do have data on US users that could potentially be subject to some sort of requirement from a foreign adversary to turn over that data, to simply have a firewall that completely prevents access to that data from outside of the United States. And then second, you see that a lot of the concern of the senators were on issues like, I don't like the content that's appearing there. And frankly, the content can be very vulgar and problematic and dangerous. But if we're trying to regulate the types of speech that appear on a platform, banning that platform is not the way to do it. It's not something that's consistent with the First Amendment. If you want to have a country where people have the right to say what they want to say, then we should make sure that platforms are not being required to sell or divest simply because senators don't like the content of what appears on those platforms. So that's what I think is happening here. When you look at the Supreme Court opinion, they just take it as a given that the government's purported national security concerns are valid and problematic. But I don't think that they actually spent time engaging with technology itself to say, are there possibilities for firewalls, for example, to block this? Is there a way for other legislation to protect this? For example, if we had a privacy regulation in the United States that actually would protect all US users, including from US companies, then that would help to address those concerns, saying you can't collect certain types of data. For example, there are some states that have protections like Illinois that say you cannot collect certain facial recognition data. And that's why those platforms will not return that kind of facial data to the server. It'll store it only on your local device. So for example, if you use a filter, as you mentioned, and you want to put glasses on yourself, they have to know where your face is to do that. But there are privacy laws in place under state laws that prevent the maintenance of that data in certain circumstances by that company. So it's not like there's even a possibility for the Chinese government to say, hey, show me the faces of these users, show me their pupils dilating, all of that. That data is not sent back to the server. So if we were to try to develop something that focuses on the national security concerns, we can do that in a way that is more restrictive and in fact more effective and protects people not only against one particular company that the senators are mad at, but actually focuses on all companies. Same thing.
My first question to be for Mr. Shapiro. I think this last election showed us that we are changing the ways we're getting information and news in this country, leaving this traditional news platform, focusing social media. This bill that the House and Senate passed and Biden signed, it's been delayed for another 75 days. Is there any future implications that you see going forward to other social media platforms? I mean, maybe ones that aren't majority owned by a foreign company, but maybe have a 30% interest in.
I don't think so. I mean, the court's whole ruling was based on the foreign ownership and the hostile foreign ownership. And so this does not set a precedent that if in the future, Congress doesn't like that Facebook or Twitter or X or whatever is collecting too much Americans' information, and they do the same thing, you have to, split yourself up so that the data is not all collected in the same place or some, argument like that. This does not provide a precedent for that. The court, nor does it provide a precedent for the types of arguments that you saw from a couple of the congressmen about the concerns that I raised at the very outset of my comments about, well, this is just a bad platform. It warps kids' minds. It warps our political discourse. The court very much focused ultimately on the data collection bit of it. The court below, the DC Circuit, also kind of by judges appointed by presidents of different parties, spoke more to the kind of algorithmic manipulation and control. But no, this is a unique problem with the foreign hostile ownership.
Well, a similar question to Professor Laser. And we mentioned this, there's first minute notifications here. Do you see this restriction to TikTok having an effect on First Amendment rights as it relates to social media in our future?
Yes, I do think that it sets a dangerous precedent to have an act like this that is effectively forcing the ban of something that senators don't like. Now, I think that they very carefully crafted it to try to make it more likely to survive the type of First Amendment scrutiny that we see in our body of law by focusing on these national security concerns and to try to make arguments that there were no less effective, less restrictive means of doing so. The court seems to have taken the government's statement that there's no less restrictive means of doing so as a given and dismissed without actually looking into the technical realities, dismissed the possibility that there were ways to do this without affecting a ban. If you are going to ban content platforms, that's going to have a negative impact on the ability of people to speak, especially when those platforms are being banned because people are concerned about the content on them. You could imagine that this act was carefully tailored to this specific situation, but I would not be surprised if in the future it emboldens senators to say, well, if we see a Russian interference campaign taking place on a regular basis on Instagram, that we should put some restrictions on the type of content that can appear on Instagram. I personally, as much as I don't want that kind of content to be on the platform, I don't think that it's the government's place to tell a private company what they can and can't have on their platform or what people can and can't say on that platform. I think it's a dangerous precedent to set. In this case, they were careful and they're not going to be able to use this specific act to extend to, say, Instagram, but I could see it applying in other places as well. We've seen since the TikTok ban, a lot of users have flocked to RedNote, which is an app that's actually controlled by way worse. It's actually controlled by the Chinese Communist Party rather than just, okay, there's a Chinese citizen who has 21% ownership of this company and he can't access the data anyway. It's a very different set of circumstances. It
would set a precedent. This case does set a precedent for banning RedNote in the US, certainly.
Absolutely. I think this particular act could already be used to ban RedNote, would you say?
That's right. I think that's right. What's interesting though is in the example you gave of the Russia sowing misinformation or trying to sow chaos in our political culture or election or what have you, allegations about that in 2016, 2020, what have you. There, a ban on Instagram or Facebook would be a different sort of thing because it's not that Russia owns Facebook and is using that. It's an actor in the app, and so banning Facebook would. I don't see how that would be upheld because it's not like an ownership thing. At that point, it's a definition of and regulation of disinformation, misinformation, and certainly the Trump administration, which just issued an executive order against censorship on social media, is not going to be engaged in something like that.
That's probably true.
I guess sort of a nice question we talked about. So talk about the TikTok ban as being a prohibition on what's going out, the information going out. But as we mentioned with the Russian information, but probably to the 2016 election, we have the information coming in from other countries as well. And we spoke, you guys both spoke on it a little bit, but what do we see for the future going forward? How this specific opinion and this specific bill is going to affect information coming into social media from other countries?
I mean, it depends on what some future regulation is going to be. If the idea, you know, the government is, it has started under Biden, now continuing under Trump, is discussing AI regulation and deep fakes and all of these things that you could imagine could have an effect, whether on elections or on political discourse, American culture in general. You know, we have a record low societal trust in institutions and what have you. Our adversaries want to, you know, keep that going rather than, you know, improve our culture, what have you. And AI tools can accentuate that. So what are you going to do? Again, I don't, you know, that kind of case is going to involve, okay, well, that's clearly not content neutral. You're regulating content that is meant to divide Americans, you could imagine, or meant to inflame tensions, or meant to influence our elections, or however you want to define this under the proposed regulation, executive order, legislation, what have you, which would by definition be subject to strict scrutiny and would have a lot of, I think, First Amendment problems, because you're trying to draw lines about what is and isn't allowed, what kind of speech is and isn't allowed. And here it's not, okay, we're trying to, you know, we've identified this is Chinese Communist Party trying to sow chaos, whereas that's just teenagers being stupid and trying to convince each other to commit suicide. And if we want to block that, that's a different kind of rationale. So I think it's a different situation.
Yeah, I think this particular act would have no impact on the likelihood of foreign interference in terms of psychological warfare using social media platforms, because it doesn't change their ability to affect virality of content. It doesn't change their ability to pay for promotion of their content. There's nothing in this law that would change the amount of foreign interference that we see from using social media as a means to influence public opinion. That's going to continue to be available on every other social media platform. And if TikTok is able to divest, will continue to be available on TikTok to the same extent. The ability, if you look through how TikTok has described its corporate structure, the ability of ByteDance to impact the algorithm that's viewed by Americans and the way that content is promoted is rather limited, because that is handled by regional reviewers that are based in the United States. I don't think this law is going to change anything from the perspective of that psychological warfare concern. The only thing that it could potentially impact is a future hypothetical concern that has never arisen and that the CEO said would likely not arise, of the Communist Party requesting data that largely TikTok doesn't even collect. So I don't think it's going to have an impact on the things that the senators seem to be expressing concern about.
So the Congress, the senators, representatives, the lower courts and the Supreme Court, which were all unanimous, the judges were all unanimous up and down the line of this litigation, were all misunderstanding the way the technology works, you're saying?
I think that the
Or
Supreme
gave
Court-
undue credence to the government's
Yes.
misstatement about the technology?
I think that the Supreme Court gave undue credence to the government's perspective on how the technology works, and didn't give enough credence to the way that the company itself described how the technology works, in part because when you look through the companies, through TikTok's description of how the technology works, and especially their proposals to have these sort of firewalls that prevent foreign access to US customer data, it seems to me that they didn't adequately describe why that was not sufficient. And the Supreme Court instead said, we give the government wide leeway in these intermediate scrutiny cases to say what they believe to be the national security concern. So perhaps it was legally correct for the Supreme Court in an intermediate scrutiny case to not consider that. But I also think it's true that the Supreme Court did not understand and chose not to investigate or explain or explore the potential technological alternatives that would be least restrictive here.
Well, I mean, the firewall is all well and good until, you know, the way corporate governance works, the parent company demands something, some alteration, and then the government, which controls the parent company, I mean, it's, you know, it doesn't happen until it does, and the court did find this, I thought this was the best quote here. The record reflects that China, quote, has engaged in extensive and years-long effort to accumulate structured data sets, in particular in US persons, to support its intelligence and counterintelligence operations. So it's done that in all sorts of ways. Why would it say, well, we're gonna refrain from doing it in this thing that is on half of all Americans' phones? I mean, kind of, you know, the court generally isn't equipped to second guess government intelligence determinations. And without even going into the classified materials that the government submitted, it was able to do that. I mean, you know, you have people on the court and on the lower courts that have come from all sorts of different perspectives on the importance of privacy and how you balance First Amendment interests and what have you. And they all were okay with that. I don't think making it intermediate scrutiny rather than strict scrutiny would have changed that. I mean, Gorsuch said even under strict scrutiny, it survives. I think they just didn't want to take it up to the strict scrutiny level when they didn't need to.
When you mentioned that particular quote about the Chinese government collecting those data sets, it's true, the Chinese government does collect those data sets, but oftentimes they collect it through other means. So for example, one way to do so is by using data brokers to simply purchase that information on the open marketplace. And that information is widely available. You download any app, it's going to be tracking, unless you select no tracking. Any app that you download is going to be collecting data on you, which oftentimes they sell to data brokers, many of which are Chinese government operatives that are trying to collect database and information on US consumers. Simply banning TikTok from transmitting that information directly through this process of divestiture doesn't, in my mind, I think, limit the Chinese Communist Party's ability to continue to gather that information from all sorts of other public sources.
It's different information, and it's obviously easier and cheaper to get it directly rather than hunt it out, pay for it, whatever's publicly available and all that. I mean, this law doesn't, you know, solve all problems with Chinese espionage or what have you.
Yeah, in my mind, I don't think it actually limits Chinese espionage at all, and it's based on a hypothetical concern that could have been addressed through other technological means. And the Supreme Court chose not to question that, as maybe they're right under an intermediate scrutiny approach.
This brings us to my last question for you guys to return over to them. You guys brought it right to the perfect point. The opinion of the court ends with this statement of whether this law will succeed in achieving its ends, I do not know. A determined foreign adversary may just seek to replace this one law surveillance application with another. And then it says, as time passes and threats evolve, less dramatic and more effective solutions may emerge. Now, in your opening statement, you mentioned other alternatives to a complete ban, and some might see this.
Just to be clear, that was Gorsuch's concurrence. That wasn't the court's.
Concurrence. And some might see this complete ban as a overreaction or an overstep. What are we thoughts moving forward? Is this ban going to be seen in 10 years as an overstep? Is this ban going to be seen as a pioneer in the field of regulating social media from foreign adversaries?
Yeah, in my mind, this approach that the government has taken and the Supreme Court's opinion here shows that we're taking a step in a rather, I'll call it almost authoritarian type direction, where the government is going to be trying to carefully get rid of content that it doesn't agree with, rather than actually trying to make this an environment, especially on the internet, where freedom of speech has been so fundamental, not only in the United States, but also for United States leadership across the world on the internet, that we have to give people the ability to speak and to communicate, even if that speech is speech that we don't like, even if that speech is harmful to national security interests. I think that if we don't allow complete freedom of speech on a platform, unless that content is actually illegal, like child pornography or copyright infringement and things like that, which is already the only types of things that are currently allowed to be limited under the Communications Decency Act, for example. if we don't go this direction of freedom of speech and free and open internet, it creates a dangerous precedent for the United States that I don't think the government should. I don't think they should take that direction. Now, I think that there are legitimate national security concerns that could be addressed through other less restrictive mechanisms, and that it's the responsibility of the government to learn and understand technology so that they can carefully craft legislation to actually match the national security concerns. And here, when you look at some of the other clips from the hearing, you'll see senators who don't understand that a Wi-Fi router is necessary for using the Wi-Fi to access TikTok. They don't understand how microphones on cameras work, or thinking that they're checking for pupil dilation. It just shows a complete misunderstanding. One of them even said, "Oh, I don't even know that Singapore is a country." Had no concept of the idea that perhaps this CEO who is Singaporean is not Chinese, just had no concept of that. And the level of misunderstanding that's reflected in those hearings is problematic. I think it's our duty to elect representatives who understand technology, who understand global concerns, and who understand what the real threats are here and how they're actually happening in the world. The most, in my mind, dangerous threat that's happening is from this psychological warfare, but it happens on every platform and anybody can do it. So this is not going to do anything in my mind.
I'm happy to stipulate that the average member of Congress doesn't get the technology. I'm pretty satisfied that the chair and vice chair of the select committee on the Chinese Communist Party, Mike Gallagher, Republican, and Ro Khanna, Democrat, are very well versed and sophisticated in this stuff. So happy to defer to their judgment on that. I will say one more thing. It's curious that the challengers were TikTok and ByteDance on the one hand, and ByteDance doesn't have First Amendment rights because it's a foreign actor, and a creator or several creators. Users actually were not the plaintiffs. I wonder if there's any additional analysis that the court would have had to go through if there were claims that, well, we Americans want to be able to use and communicate with this on this app, although it probably would have been collapsed into the same sort of analysis as was replying to the creator.
I agree.
Well, do we have any questions in the audience? Yes, John.
So one of the arguments that I was thinking of, I know many users that
Feel free to post this debate on TikTok though, to kind of make it meta.
Absolutely, and we'll also tag all the Chinese hashtags.
the main arguments seem to be First Amendment based arguments. And I was wondering if maybe they took the wrong approach and they should have gone with saying a Fifth Amendment argument, saying that this is a property because there are users that use the to market their content, to market their businesses, to actually sell services that they're selling to all the post videos. And the fact that government done here is they seems to what you think on that.
So I filed briefs in a lot of regulatory takings cases, and that kind of argument is clever, but it wouldn't cut it because it doesn't destroy all value. You don't actually own the app. I mean, there's all sorts of issues with regulatory takings claims. There's also, you can assert economic liberty claims, which are even more disfavored and things like that. But no, I mean, this is the First Amendment claims are I think were the strongest ones that could be asserted, and ultimately the court decided that those were either overcome or not implicated, depending on which challenger you're talking about.
And if you look at the opinion immediately below this, they did talk about the takings issue and bill of attainder issues. On the taking clause, they said that a taking would only happen where a regulation completely deprives an owner of all economically beneficial use. And it said here that the diminution of value is not actually depriving the owner of all economically beneficial use because they're theoretically going to sell it to somebody else who would pay fair market value. So that's why they dismissed the takings clause issue. And then on bill of attainder, which was another approach that they looked at, they were saying that this is not a act that's specifically targeted to punish an individual for past behavior, which is one of the things that you need for a bill of attainder. Now, I personally would have loved to see more exploration of the bill of attainder arguments, but I agree that the one that poses the greatest concern is the First Amendment one. But I would have loved to see more discussion of bill of attainder.
We have a question online here. It's by focusing almost entirely on the content argument for the First Amendment analysis. Do you think TikTok missed an opportunity to make a freedom of association argument that they are not able to divest, considering that social media is now being viewed as a gathering place for individuals? And if you have any thoughts on how that might have turned out. This is, they mentioned secondary that this is a TikTok and a TikTok and a creator's petition kind of argument.
What's your perspective?
You know, I mean, practically speaking, if the court wasn't going to go for a speech argument, I don't think they're going to go for an association argument. And you know, you're not allowed. There are all sorts of national security regulations that you're not allowed to associate with, you know, foreign agents and things like this. You have to register if you're lobbying on behalf of. Yeah, all of these things are, you know, regulations in the name of national security are done, so then it just collapses into whether it's narrowly tailored enough to achieve that goal.
I think one concern here is that the feeling of injustice that people are having at this doesn't fit perfectly within traditional legal recourse. I think a lot of the feeling of injustice is this sense of, well, don't take away, users saying, don't take away this thing that I use to communicate, creators saying, don't take away this thing that I use for my livelihood, and that it's simply not fair to take it away, and saying, I don't think that those national security concerns are justified, or that this is the right way to address this. And I think that that might potentially be better addressed through political means of contacting your representative and saying that I disagree that this is a helpful act to pass. It's so hard to get these things tossed out on legal grounds like First Amendment. But I think the concern that people have is really a political one, saying we don't actually want this act to happen. And we don't think that you senators understand the issue enough to pass this the right way, trying to address national security concerns.
I think that's right. And ultimately, I mean, imagine kind of the worst possible scenario. This very popular app that everyone knows and the Chinese admit is a spy app, and it's collecting all of our data and using it to just do the worst things imaginable that someone who control that data, control that algorithms, etc., can do.
Let's take Red Note. I think.
Sure, Red Note might be closer to that. Sure,
Yeah.
but what, you know, the worst possible app, you know, but people are still, you know, half of Americans use it. You know, they use it to communicate. All the same argument. We advertise all this stuff, right? If you agree that the government can force divestiture in that steelman scenario, then what we're arguing about is precisely what Professor Laser brought up about whether the court is understanding the technology properly or unduly deferring to the government statements about the technology.
I know that Professor Laser has a class to attend here.
I can stay another 5 minutes.
So we have one more question here. We'll take from Don.
I came here because I've just been big client and I don't think people are knowledgeable to understand the health concerns when it comes to social media. Where this situation occurred, I'm pretty sure the US labeled social media in its entirety as a national health concern, as they did with cigarettes. And correct me if I'm wrong, stated that TikTok might have helped President Trump with campaigning or giving funds. That's right.
No, Jeff Yass, who's an investor in ByteDance, had a meeting with Trump at some point, and Trump changed his tune about TikTok, right, between the point where he issued the executive order to ban it, and that was blocked, and the time, you know, very recently where he said, well, I don't know, it's popular, my people like it, that sort of thing. I'm very popular with the young people who like it, stuff like that. There's allegations that, it was influenced to change his mind by supporters.
And with that being said, I don't know how much of because it's still there are still certain type of technologies that are made by China that Americans use. So I think that's kind of bordering the line. And also, even if there is a change in ownership, I genuinely don't think, I do agree with the first later, I genuinely don't think that will change as much, or enforce as much security as they might be. Because, China is a very smart country. They have a lot of language and strategies that they can implement to gain information. But I'm more so concerned, and I think it's good that this is happening because I am concerned about the extended stimuli that comes to use social media that people might not be aware of. So I think
My attention span is definitely lower than it was 10 years ago.
yeah, and I think that can say that maybe it just needs to be a broader, just not the data, the taking the data from TikTok exclusively, but more so all companies.
I mean, look, social media and smartphone issues, the Jonathan Haidt's best-selling book, The Anxious Generation, especially for kids, these are real concerns. They're real concerns. It's definitely a policy discussion we ought to have.
I would just add that you're absolutely right that there are many other ways that the Chinese government can collect this data. One of the common ways that they do so is by putting agents as engineers within these organizations, but they oftentimes do that within US organizations as well.
One more quick question to piggyback. Do you believe this like Band-Aid law will lead on national regulation?
Oh, that's a great point. I think fundamentally, if people are concerned about this information being accessible to the Chinese government, what they need to do is to convince their legislators to pass laws that prevent the collection of that data. Because if the data is collected, there are many ways for foreign governments to get access to the data. For example, by having agents infiltrate many of these US organizations. If we don't have privacy laws that apply equally to US corporations, that data is going to get out there anyway.
And yourself?
Yeah, I think I agree with that.
Do you believe that this will lead to government?
I think it raises the concern that there's always been from both the left and the right, kind of, privacy hawks that are concerned. I mean, it's a balance, right? Because if you're not, these platforms are free for us, right? Because we're paying for it with our data. So will innovation slow if there are all sorts of regulations preventing cookies and all the rest of the stuff?
And that's probably true that we would not have quite the same level of innovation on these platforms if there were countervailing regulations, but you have to pick and choose sometimes.
Well, guys, I'd like to say thank you to both of our speakers here today. Appreciate coming in, and thank you for showing us our event. Next month, February 25th, we will be having Judge Calabrese, Federal District Judge, in here to speak to us. Report to them.
Thank you. That was great.